get into the conversation, let me just give you a quick update. We're very excited about a kind of a monumental event in Arizona that happened about 2 weeks ago. A bill was passed, and Governor Ducey signed into law House Bill 2529. And you would say, well, what industry wants regulation, or what industry wants any kind of governmental oversight? And in this case, it's different. Since I've been involved in the senior placement referral industry for 15 years, this industry has been, and I often say we've earned our reputation. We've been maligned, and rightfully so, because there's so much corrupt, underhanded, I would say hidden kind of behavior by a number of agents and agencies, and that's changed quite a bit over the last 15 years, but there's still a pretty strong element that is unrestrained at this point, as I would say it. And this bill that was forged out of, with our friends, the assistant partners, primarily at the Arizona Leading Age Group, which is a trade association representing a number of the large assisted living providers, pushed forth the issue that disclosure and written disclosures between agents like myself and families that we work with would be a required thing now. And so we're all at our trade association, the Pastors Group, and our National Placement Referral Alliance are working quickly to develop templates and in communication with the agents that are part of our membership to be in compliance with the law immediately, and that all of the families that we serve going forward will have a written disclosure from us. And so it's very important for referral sources, professionals that work with us as agents, know that we're in compliance with the law. And leading the way is the trade group, the Pastors Group, that we founded 8 years ago to be that voice and professional group representing our industry. So I just want to give everybody a little update about that. We are excited about a law, even though it's kind of weird to say that. But anyways, there's our update, House Bill 2529, more to come on that. So we wanted to do a series, you guys, and Marsha is our first guest in this series, with friends and colleagues from the legal world. And today we're going to talk about our presentation is titled Best Laid Plans, How to Stay Prepared for the Future. And it's really been an emotional trigger for me that as I'm in my mid-50s, I'm looking around a lot of the clients that we serve and people we work with that are not far away from my age, and some even younger than myself, that weren't expecting things to change, and how life can change. And I stood in the emergency room 2 weeks ago and watched my brother nearly lose his life with a significant illness. And so it's very personal. It's very humbling. I just got word that the guy I went to high school with is struggling with cancer. So this, even though we work a lot with the senior population, we're talking about really anybody, Marsha.
Absolutely.
And so as we came in today, I was thinking, man, I met Marsha about 10 years ago, and she was just entering into the service of seniors, primarily seniors, but this world after a career in business, which followed a career in law. And so I'd love for you to just say thanks for joining us and tell everybody how we met, and then Bob Ross' office that day, and then we'll just kind of go from there.
Thanks, Scott, and thank you for this opportunity. So as Scott said, I graduated from law school many years ago, and we don't need to say how many, and I practiced law in Michigan for several years, and I gravitated from practicing law more and more into business. I went from a law firm, and then I became in-house counsel in a large corporation, and then from that opportunity, I was very interested in the business of the corporation and moved to a role that was really on the business side and the sales side, and had the opportunity then to come to Arizona and own a business that was not in the legal field, and I enjoyed it very much. But you know, the economy changes and goes through cycles, and in 2007, 2008, I had the opportunity to sell the business, and it's like the time was right to get out of that. And so then I didn't realize at the time that the sort of mid-career, re-careering was a thing. I thought it was just me, but apparently it's a thing. So I knew that I wanted to work with seniors. I didn't really know how. So I did take the Arizona bar exam so that I could, reactivate my law license. And then Bob Roth, who many of you know, if you're listening in Arizona, he has a Cypress Home Care. We shared a CPA, and then we also belonged to the same synagogue. And so people said, you guys need to sit down. So I sat down in his office with the whiteboard, and we spent an afternoon, he and his staff, just listing all the people that I should meet while I tried to figure out what I wanted to do in my next chapter. And one of the people they put on that list was Scott.
I was on the whiteboard.
He was on the whiteboard. And another person who folks may know is an elder law attorney out in the West Valley named Rita Danager. And she also had come to Arizona a little bit later in her career and started her law practice in Arizona. And she sort of got me started on how I could establish myself as an elder law attorney. And I've been very grateful to everyone who helped me get started, and love it when I have the opportunity to give back a little bit.
Well, and one of the things that I really enjoy working with you when we have, in addition to having to for yourself, you've always had a clinician, a clinical person involved, because so many things the families, the people we work with, there's a lot going on. And so having that clinical person is a great resource for you and for me too.
Thank you. Yeah, and I just, before we go into the substance, I've always had an elder care coordinator is the title. Right now it's Tracy Swanson, and she's an RN, and she doesn't, if you will, practice nursing, just like Scott, who's an RN. But she has that, so we help our clients and their families sort of navigate this whole landscape of, and there's so many people will call and they think all they want to know is, I need to apply for Altex, or I need powers of attorney. But to understand how to best help them, it's impossible really not to get into the clinical side of that. But that's not my qualifications, so I have the partner who can help me.
And being that we're in Arizona, particularly Maricopa County, where we have such a high concentration of seniors, we have a higher concentration of resources, good, bad, and ugly. I mean, all the above. I mean, outstanding. And then we have, an elder care coordinator like Tracy at this time really helps your families find their way through and utilize us resources, but other companies for resources along the way.
Thank you.
Yeah.
So should we get started?
Let's do it. So we're going to just turn Marsha loose here, and maybe. I don't know. All right.
Is that really the next one? Okay. If the slides don't make sense, then we'll blame Scott.
I think, yeah.
If they bounce around. So first, as Scott just mentioned, so my practice, life care planning, includes asset protection and coordination of private and public resources. And so I say to my families, we help them find, get, and pay for the care they need. So that encompasses, what's the best care for the person? How do you qualify? How do you pay for it? So that's my practice in general and why it works so well to have the clinical person. But today, in the time that we have, I wanted to talk about the legal documents that every adult should have, but often the seniors that we work with, the most part, are people with disabilities, we find have not done that yet. So we'll talk about powers of attorney and advance directives, some of the other advance directives, which are the DNR, living will and other expressions of your intentions. What if you don't have these documents? Because sometimes, unfortunately, it is too late. And so what's going to happen then? And then a little bit about disposition of property, your will and a trust. We were just chatting here in the office, and someone was saying, does she need a will? Does she need a trust? And I always say, I'm more concerned about you and your care, not about your stuff. Mm-hmm. But the fact is, we spend a lifetime building our financial legacy, and that's important too.
Right.
So powers of attorney, what are those things? What are durable powers of attorney? What are that whole set of documents? Who should have them and why? What do they accomplish and what don't they accomplish? They don't necessarily do everything people think they do. And how do you keep them current? So a durable power of attorney is the document in which you appoint someone to handle your financial affairs and contractual affairs when you're not able to. And so really every adult should have this document in place. And we think of it more for people who are elderly, but, here in Arizona, how often, a couple times a month we hear about the wrong way driver. Yeah. Unfortunately, something can happen to someone at any age. And with the elderly, we're thinking maybe more their decline and then somebody takes over for the rest of their life. But it can be just as important just for a temporary period, and also even people in the military. There's lots of reasons why you should have that document. And it's important to choose a trustworthy adult who will have your best interests in mind. People think of their children. Not everyone has children, or unfortunately, children sometimes might not be the best choice. Even if they are not sort of inherently dishonest or, especially in the financial crisis days, if someone, let's say it's your child and all of a sudden he loses his job and he has trouble with his mortgage, then, he's has access to mom's bank account, and sometimes it just kind of snowballs. And I'm not saying that would happen, but it's more important to choose who you have confidence in. You're not going to hurt anybody's feelings, right? Because it's a responsibility and an obligation to do this. I have people say, well, what if, even my own mother, I'm the youngest, and so she would sort of feel like she should include my older brother, and he's someone who maybe didn't manage money that well. And, and so I said to her, I'm not going to do it with him. Don't put us in a situation where we have to argue about it. Right. Pick who you think will do it.
And I'll talk to families when this is when the kids might be at stake against each other or contentious, is how did they get through this, or who, when the parents selected the one over the other, it can create some contention.
It can. And so what makes it durable is the language in there that this document continues in effect even if the principal becomes disabled. And that's that's sort of the point of it. Now, as opposed to a limited power of attorney that, I know that when I moved to Arizona, my husband stayed behind in Michigan to sell our house. And so I executed a limited power of attorney so that he could sign, this was before you could do it online, so that he could sign those closing documents on my behalf. And that was the sole purpose of that limited power of attorney. And whether he used it for that or not, it expired. Versus this, we're talking about a general power of attorney that can be used for all different kinds of transactions. And lots of times the banks have their own form, and they like you to use their own form. And the banks can be difficult to deal with.
I was going to ask you about some of the trouble sometimes families will tell us.
Oh, some of it, it's like they make up their own rules. I've had bankers say, well, the power of attorney isn't good because it's more than 5 years old. And that is, I would say, well, this is a person who was smart enough to plan when they were capable of doing so, and just because it's been a long time since they did that, it didn't expire. Right. So sometimes you need to do a little pushback with the banks. I always say to people, if your bank has its own form and you have the ability to do it just makes your life easier. But you still would, that works only for the bank, and you still would need it for other purposes.
Selling property.
Or other contractual things or that sort of thing, And there is something called a springing power of attorney that doesn't go into effect until the person is disabled. And so there's language in there where the sort of the standard or the normal durable power of attorney can be in parallel. And I always use my mother as an example that she, toward the end of her life, was sharp as a tack. I would get investment advice from her well into her 90s, but she wasn't very mobile. So if she could do something, she could handle something on the phone, she did it herself. But if I needed to go someplace and meet with someone, then I could use her power of attorney to accomplish that. We could both have the authority, kind of in parallel. A springing power of attorney says that it doesn't go into effect until the person the principal, the person who signed it, is disabled. And that requires usually a doctor's certification. And that's not my favorite for a couple of reasons. One is sometimes the need is sort of urgent. And so then at that point, you'd be sort of running around trying to get these doctor's letters.
And doctors don't want to do it if they don't know the person, like the hospitalist or whatever, that the person's in front of them for the first time. They don't know that the wishes of that person, as long as a relationship there.
That's right,
Yeah.
exactly. And then also, now that you've made public a statement from a doctor that says this person's incapacitated, it's, stapled to their power of attorney
Right.
and shown to a bunch of strangers, that's not my,
Right.
but having said that, some people just aren't willing to relinquish that control.
Mm-hmm.
And so having the springing power of attorney is certainly better than nothing.
Okay.
And especially if it says, a letter from their own doctor, so then you can go get that letter. And the power of attorney does expire on the death of the person who signed it. That's commonly misunderstood. So if your loved one has passed away and you're trying to get bills paid and so forth after they have died, which is a very normal thing to want to do, at some point when people realize that person has passed away, it no longer has that effect.
Okay.
And advanced directives, those are powers of attorney or whatever that relate to healthcare type. So there's these express your wishes about medical care, and you appoint someone to advocate for you when you can't do it yourself. Now, this, by definition, only is in effect when you can't speak on your own behalf. I always tell the story. I had a woman she was in hospice, she was declining, but she was mentally all there. And her daughter called me one day in frustration and said, they keep asking my mother what she wants. And I said, that's good. That's who they should ask.
Yeah.
You cannot overrule that competent person. So that includes and I'll kind of go through what those are. And again, select the person that you trust who shares your philosophy. This almost more, if you have a very strong belief about that you want everything possible done, or the opposite, you only want palliative care, if the person who you're asking to advocate on your behalf has a different view, you're really putting that person in a difficult position. So there's no reason why it would be the same person who has the financial power. Even within families, someone is a little bit more empathetic, someone's better with money. It's what.
Well, here's the question that comes up. So if there's kids, and one is one and one is the other, and they're executing a residency agreement and an assisted living, who signs the residency agreement and who makes the decision on where they live? That's
a great question. In my opinion, the healthcare power of attorney is the person who makes the decision about where they live, healthcare and where they live, and is also, in my opinion, can sign the contract.
Okay.
But that person, it's hard to imagine. It's possible that person wouldn't know the financial situation. I would like to think that at least be aware of if they could afford it.
Usually, if they're in sync on the decision, one's handling one, one's handling the other. I've seen either sign. More often, the financial power of attorney sign the document, all the stuff to the civ who handles it. I've been in situations that are being contested where you've got a private fiduciary on one side and somebody else on the other, and now it's who's doing what. Can you?
It can be, but all in the situations that we hope most are in, that healthcare power of attorney could sign.
Could handle that. Okay.
And then when we talk about making changes, as this is one of those things that you really should pull them out every 5 years and take a look at them, because your views change, or sometimes people only name their spouse as the agent, and the spouse is incapacitated or passed away, and so then you might as well not even have it. So to just kind of make sure it's current. And we mentioned Bob Roth before, and he and I have been on a lot of panels together, and he apparently actually listens to me, because when his children reached age 18 and went off to school, he had them come to the office and do powers of attorney, because those of us parents or family members, we don't think an 18-year-old is an adult, but the law does.
Yeah.
And so if in the absence of him having signed the power of attorney, if his child in another state had a car accident and was in the hospital, or even just was sick and in the hospital, they would not share information. The fact that he's the father doesn't matter. So you wouldn't. So really, even when you think about your young adult children, should document that they would want someone to be able to do this for them.
Absolutely. This issue is one of the hot topics at the on a healthcare committee task force I'm a part of at the AG's office, and we've been studying this issue for about a little over a year on the significant lack of documentation by Arizona's adults. And the Secretary of State has this database registry where families can put those advanced directives. Many of them are outdated. They've been they've been ordered under law now to make it available to first responders and healthcare professionals, because when you go to ER or when the fire department shows up and those advanced directives aren't available, the first responders are like, what do we do? Sometimes they resuscitate people that don't want it. Sometimes they do,
Right.
So this issue is so prevalent that the AG's office has been studying this for over a year on what to recommend for further legislation or policy for the state.
And in fact, you mentioned the registry that Arizona does have at the Secretary for your advanced directives, and you access it with a PIN, but someone pointed out, where is that? So the person comes to the hospital on an emergency basis, like, is it in their wallet? Who the heck knows? And so I was actually proud to be part of that legislation to expand that so the hospitals can access that directly, because that's who's going to need to look at that.
Right.
So what are the pre-hospital medical directive, or the orange form? The orange form, it has to be orange. It has to be printed on orange paper, or like hot fuchsia, hot pink. And that is an instruction to first responders to not resuscitate.
Right.
So many times you will see some of our seniors have it on the door jamb, on the refrigerator, because basically they're saying, it has to be signed off by a doctor as well, and saying do not resuscitate as the person goes into cardiac arrest. And that is its sole purpose. So generally speaking, like I always, when I give this talk and I'm out and about, I say, so when I leave here and I'm walking outside and I'm texting and walking, and I trip on the curb and hit my head, I want to be resuscitated, because when I am, then I will be fine.
Yeah.
But if I already had God forbid, a diagnosis of stage 4 cancer, then I might say, you know what, if some kind of accident like that happens, then let's just let nature take its course. Or if I'm very, very elderly, and because that chest compression and all that, breaks ribs, but it really is it really is for someone with a diagnosis or at the end of life. Now, in that situation, and Scott touched on it, if the first responders don't see it, and so they resuscitate you, sort of all bets are off. That was the purpose of that form. They didn't see it. They resuscitated you. They're not going to then say, well, we resuscitated them by accident, so now we're going to pull the plug. It doesn't have that purpose.
Some of the responders' frustration is senior living, because they belong to independent living, assisted living communities, group homes, and those forms at the time they called in code, and then it can become problematic when they resuscitate somebody that didn't, and they have happened.
And there is a difference between the life support and the DNR.
Absolutely.
Okay, so maybe
and that's my next thing. The DNR, the DNR, do not resuscitate, that is a physician's order. That is something that is in your chart at the hospital. So those of us who've been to the hospital, really for any sort of surgery, I mean, or the knee replacements that all of us baby boomers have, any sort of surgical procedure, you're asked if you want to sign a DNR.
Yeah.
And that's in your chart for that hospitalization only. And again, that's an order to the physician or the staff that if something were to happen, if you go into cardiac arrest, you do not want to be resuscitated. And those of us who like to watch doctor shows on TV, and you see the doctor's like, I know she has a DNR, but I'm going to do it anyway. Really, that won't happen.
Yeah.
That's
TV.
That's TV. That's right, because there wouldn't be any story. But that does not take the place of a healthcare power of attorney that has to do with all kinds of decisions about, what kind of procedure you might want, or even if, back to using if you're having some sort of surgical procedure, you're unconscious, and the doctor sees something different than what they expected, so a choice has to be made. Do we do A or B? This has nothing to do with that. You need that healthcare power of attorney.
Right, and that healthcare power of attorney could be really put in a tough spot. Their aging, demented mother who now falls and breaks a hip. Do you repair the hip at 89 years old with severe dementia? Those are real decisions we see people have to deal with.
Those are hard decisions. Yeah. So the healthcare power of attorney, that's the person who's going to make those medical decisions or end-of-life decisions when you cannot communicate them yourself. And of course, we talk about this like it's black and white, and it isn't. And that's the challenge, is especially someone with dementia who is vocal and verbal, but just doesn't have the judgment to make reasoned decisions. That's when this becomes very difficult.
Right.
To what point do you still defer to them, or, and so, it's probably a topic for another day, but it's a very fuzzy line.
Yeah.
And here in Arizona, we have the mental health power of attorney, and that is, and only a few other states also have that, which basically where you choose someone not to make decisions regarding your physical health, but also if you were to need to be admitted into a behavioral health hospital, you name the person the agent who can make that decision. That language has been cleared up actually by another attorney in our office, Jim McDougall, who's also a retired judge. It used to refer to a level, and there was confusion about what that meant. And people thought that meant even a locked or secure Alzheimer's unit. It really does not. It really is a behavioral health hospital.
Right.
So those of us who work with seniors in Arizona, think about Haven Senior Horizons or SAGE, those types of locked units, you need that mental health power of attorney to make decisions.
But the healthcare power of attorney, that clarification,
yes.
Can you go ahead and place them at your Silverado memory
Absolutely.
care facility?
That's right. Absolutely.
Okay.
And
because if that happen, then you're sometimes stuck in proceedings, guardianship.
Exactly, and I touch on that later. That's right, yeah. And because really, I often say to people, frankly, if someone wants to get you into one of those, they'll get you in. You need the person with the authority to get you out. That's why you need that person. That's right. And those forms, by the way, the health care power of attorney, the mental health power of attorney, the living will are available on the Attorney General's website at azag.gov, and they have a tab that's called Life Care Planning. It used to say for seniors, and I pushed back on that because now you're perpetuating that only older people should have these.
Right.
But, so you do not need to spend money or hire an attorney to have those, especially those healthcare advance directives.
And we've kept them on our website under our tools section as well, too. We update those annually. Okay.
And then the living will, that's your opportunity to document your wishes for end-of-life treatment when you're not able to express them yourself. And I often say that this is really a roadmap for the person who is your healthcare agent. If there's a human being that the doctors can speak to, that's who they're going to take their direction from. They're not going to also look at what you have written. That gives your healthcare agent really peace of mind when they're making decisions on your behalf that it's what it's consistent with your wishes.
Right.
And that really is something that you want to take a look at because our views about end-of-life care really change as we age.
Mm-hmm.
And you can be as specific as there's an attorney in this office who was quite ill many years ago and was really unconscious. And he, after that experience, and he got better and he's back at work, he has documented that he does not want the TV on in his hospital room. Because as they always say that you can hear, and that was correct. He could hear, and the TV was on, and he didn't want that TV on. So he has now put in his living will, if I am not able to, please don't leave the TV on.
Oh, my God.
And I use that as an example, and he does also, to say that you can be as specific as you want.
That's awesome. Oh, wow.
I had a lady who had in hers that when she can eat no other food, she still wants to have butter pecan ice cream. So
there you go.
There you go. And then other expressions, your prearranged funeral, cremation, or burial, all of those, you can do those, you can pay in advance, or even if you don't, you can document what it is you want.
Okay.
If you want to be cremated, you should document it. If you have not documented, your spouse could make the decision. If you have multiple children, it would have to be a majority of the children agreeing on it. So there's a scary thought to get you to write it down. And also, or write it down. And then the ethical will, that's something we're certainly more than our possessions. Mm-hmm. We have values and things that are important to us that we want to share with our children and future generations. And my mother had, that I didn't even know was there, this wonderful sort of expression of her history and her values that was shared with my siblings and her grandchildren. And there is, some people have heard of the 5 Wishes. Mm-hmm. That has a wonderful workbook for that sort of thing, and I encourage folks to take a look at that also. So what if you didn't? What if you haven't done these documents and it really is the point where you do not have the mental capacity to now execute them? So a guardian is someone appointed by the court who makes decisions about health care and living arrangements. To Scott's example before, that's the person who could sign the contract with the long-term care. And a conservator is someone who is appointed by the court to make decisions about financial matters. And this is a not inexpensive process. It requires going to court. It's public, it's the part of the public record. There's people in the gallery who don't know you. And it requires a public finding of incompetence, that the person lacks capacity. And you just don't want to go there.
Right.
But unfortunately, if people don't have powers of attorney in place, and sometimes even if they do, if there's a lot of discord, this is sort of what happens. It's not I'm not sure what, you can't just sort of sweep this under the rug and hope it never becomes necessary, because this becomes, and then, once you're in court, then you don't really know what's going to happen. You don't know who's going to come out of the woodwork and object, or the judges sometimes have their own ideas, and,
And both of us have dealt with those,
yes.
They thought it was never going to come to this, and then the kids are in court fighting
yes.
over who's going to be mom's guardian,
right.
or they're forced to go get the guardianship, and money's in it. I mean, it's a mess.
Right, and just,
paperwork, just get it done and fast.
Sad, and it's just a mess. And so then I mentioned the finding of incompetence. So let's talk about competency a little bit. Competency is a legal decision, not a medical one. So a doctor can say, I believe this person lacks capacity to exercise, to sign financial documents or whatever, but that's because he or she is following a standard in a legal document.
Okay.
So the power of attorney, like that springing power of attorney, might say if a doctor has to find this or that. And the same thing with the guardianship, that one of the requirements for a guardianship is to have a physician statement that says the person lacks capacity, but that's just input for the court to make their decision. And as I said, it's often governed by the terms of a document, and there are different standards for different purposes. There's a booklet, a guideline about capacity that's jointly published by the American Bar Association and the American Psychiatric Association, and it's over 100 pages long. So because really capacity or competency is a sliding scale from. Sure. So that's why we're all familiar with the laws where someone is over 65 and they buy a new car, yep. that they have, I think is it 48 hours that they can come back and say, like, a cooling off period. Yep. Because the understanding is it's difficult maybe for someone who is elderly to understand all of that fine print, to withstand the pressure, frankly, from the salesperson, that takes a high level of competence to understand those kinds of documents. And then on the lower level, probably the lowest, is what would be considered testamentary capacity, the capacity to write a will. And that legal standard is that you have a general understanding of what you have. So you would know, I own a house, and I have a bank account, and I have a brokerage account, and who you might be leaving it to, and that you have a bar exam phrase, a donative intent. I have this stuff, yeah. and I have 3 children, and I want to leave it to my 3 children. Okay. Or I have 3 children, I have 4 children, but one of my children moved away 20 years ago, has not been in any contact, and so I don't want to leave that child anything. That if you can make that expression and it does not appear that you're under duress, then you have the capacity to do that. And that, I use that same general standard for powers of attorney. And, because so sometimes someone, I as an attorney, and I can't think of an attorney that ever would sort of have the child come in, prepare the powers of attorney, and give it to the child to take to the parent to sign. I need to sort of lay eyes on that person. I'm not a doctor, but I can have a conversation. So and the capacity and memory, judgment and memory are not the same thing. And I met with a woman in her home. She was a recent widow, and her memory was declining. But her son introduced me, and we said, do you know why she's here? And what she said was, well, my husband used to handle all of those sorts of things, and now he's gone, and so I need to sign something so my son can help me. Well, that's a pretty darn good description of a power of attorney, and she wasn't really prompted, and I felt that she understood. Now, in that 30-minute conversation, she asked me what law firm I was with, 4 different times. But just because her memory was declining didn't mean that she didn't have an understanding of what she was signing. Right,
and there's an inverse to that. There's people with memory, and their judgment and insight is shot.
You're exactly right.
You can meet the opposite of that.
That's right. That's exactly right. And then I wanted to talk a little bit about So we talked all about the personal decisions, a little bit about, because this is about planning, planning as it relates to your financial assets. So the last will and testament, have you made the arrangements, other arrangements to dispose of your property? So, for example, on your bank accounts, you can have a beneficiary designation. That's a transfer on death or a pay on death. Life insurance is going to go to the beneficiary that you named. If you have IRAs and 401ks, you name a beneficiary. That takes care of the distribution of those assets. It doesn't go through your will, for lack of a better word. In Arizona, we have a wonderful vehicle called the beneficiary deed, where you record this document that says, if I own my home when I pass away, then I want it to go to my 2 kids. And again, that avoids the probate process. It's very efficient and inexpensive. It's not very sophisticated. So in other words, if you say, I wanted to go to my 2 kids, but if my kid dies before I do, then it goes to this person, you can't really use the beneficiary deed to do that sort of thing. But I would say that even if you have pretty much disposed of your personal or dealt with all of your property in that manner, it probably still makes sense to have a will, if only because to name that personal representative, a lot of folks refer to that as an executor. It's just a different term. Because there still often needs to be, who is the person who can interface with third parties to say, this is what they want, or here are the documents. The example that I always use, because it makes me nuts, is, so the person has died and they're still getting charged $200 plus a month by the cable company for something, and they will not shut that off until you can document that you have the authority to make that decision on behalf of this person who is deceased. So it's, the simplest of wills, to name a personal representative and to say what you would want done with any sort of random assets that are not otherwise covered is worth doing.
Gotcha.
And then, does the trust make sense for you? And really, what's every lawyer's favorite answer is, it depends. So lots of times, if your assets are very simple and straightforward, even if there are a lot, but they're simple and straightforward, and more what's going to be happening with our generation is we don't have those defined benefit pensions. We have IRAs and 401ks. Those all name beneficiaries. They can't be owned by your trust anyway. So maybe, you don't have very complex assets to be held that way. That said, a good reason to have a trust is, as I touched on, if you have a beneficiary with special needs. Starting with, if you have minor children at the time, if you have minor children and you pass away, someone under 18 can inherit. So then somebody has to, go to court and have a minor conservatorship to hold the assets for that child, unless you say that it should be held in trust. Even with that minor conservatorship, then they're going to get the money when they're 18. That's like a horrifying thought. Whereas in your trust, lots of folks will say, to be held in trust and used for their education until they're 25 or until they're 30. I did have somebody once, they wanted to keep it till they were 40. She was like, what do you think? And I said, they can't manage money by the time they're 30. I don't think they ever will. And then if you have a child with special needs, true special needs, you want to have those funds held in a special needs trust that will enable them to still qualify for public benefits but have the money available for them. And another reason to have a trust, if you own property in another state, which is pretty common here in Arizona, because if you do own real property in Iowa where you came from, you would have to do a probate here and then an ancillary probate in the other state, and that's just expensive. And I have a nice little income stream of my own because people, they have their vacation home in Sun City, and so I do this ancillary probate just for that one piece of property. And if it was in a trust, you wouldn't have to bother with that. But, not so necessary for tax planning anymore, because the threshold for estate tax now is $11.2 million or $22 million for a couple.
Please,
so that doesn't come up a lot, but there are, there can be good reasons to have a trust, but I would say that not everyone needs to go to those dinners where they give you a free steak and say you have to have a trust. It really does depend on your individual needs.
Gotcha.
But you can go have the steak anyway. So. And that was, and that was really, the last slide is just, I could have done an entire, 58 slides of other resources that you might want to check. And that's just a few of them. So I see that we have questions.
So the first one says, you indicated no attorney for POAs are needed. When does this process require or need an attorney?
Well, that's a really good question. And now, interestingly, you don't need an attorney for the healthcare power of attorney. You'll notice that website does not have the general or financial power of attorney available on the Attorney General's website, because there's so much variation in what you may or may not want to do, what authority you do or do not want to give. The healthcare power of attorney, the living will, is very, if you will, statutory. Yeah. It mirrors the language of the statute. There's not a lot of variation. But for the general financial power of attorney, you may need an attorney, or you might want an attorney for that because there is variety. The same thing for the estate planning documents. You know, there are forms. Arizona recognizes what's called the holographic will. That's a handwritten will, all in your own handwriting. But you know, if you want to make, my own attorney, when I did my own planning, said, you know, people would come to her and say, I just want it simple, and her answer would be, simple for you or simple for the people who are going to have to deal with it? Yeah. Which is a great question. Yeah, yeah. And so I would say, if you have any sort of complexity at all and you want to make sure to minimize the possibility of dispute after you are not able to participate in the discussion, then it's worth it to have an attorney. You know, I say, why do I have somebody do my taxes? I'm sure I'm a smart girl. I could probably figure it out. I pay an accountant. I'm paying for that signature where it says, who do you call if something's wrong? Yeah. And I would say the same thing about using an attorney for this sort of thing. Someone else asked, what's the priority to get all these things in order? Where would you start first? Well, the powers of attorney apply even if you don't have much property. Right. You know, there's plenty of young adults who, you know, we don't have to worry about what's going to happen with their property because they don't have much. Right. So I would say the powers of attorney are, if you will, the most important. Now, I will, maybe it's my orientation when as more of an elder law attorney than an estate planning attorney, when someone comes to me for wills and estate planning, I always ask them about powers of attorney. And if they say, you know, well, I don't need it, or what's that going to cost? My answer to them is, it doesn't cost any more. It's part of the package. And I feel so strongly about this that I will not do your will if you do not also allow me to do these documents to help you while you're living. And do it all together. And I have had people walk out the door as a result to testify really meant, I mean, you know, but I would say that's where you would start. And with the exception that if you do have minor children, you should do some estate planning. The most important thing to do then is to identify who you want to be the guardian of those children if something happens. And nobody wants to think about that. But you know,
you can't leave it undone.
You can't leave it undone. Right. And then because someone will decide, and that will be, you know, the relative who you don't want. Right. So I guess it's all equally important, but for different purposes.
Gotcha. If there are no other questions, you
may want to open it.
All right. If anyone else would like to ask us a question here, we have another minute or so. Fire away. If we don't hear from you, then I'm going to sing.
Can they hear you?
Can you hear me?
The audio is open now.
All right. Well, I'll tell you what. The PowerPoint presentation for everybody that registered, we will be happy to email that with Marsha's permission, right?
Absolutely.
We're good. The webinar will be hosted on our website. Okay. And you can go to optionsforseniorliving.com, and that will be uploaded. Julie, our guys, will get it all up there as soon as possible. Be out on our Facebook page and other social media. Marsha, thanks for being with us
this
afternoon. It's been a lot of fun to talk to you and learn so much. And you guys, thanks for joining us. And we will have more information about our next upcoming programs and dates to come. Thanks very much.